In summary, Mr. Laird, this is yours, I think. It's Isaac Smith, arson.
Spending custody 109 days.
Thank you. In summary, it states in this indictment that on or about January 19th, 2025, in Jefferson County, Texas, you committed the first-degree felony of arson with intent to damage a habitation. Damaging or destroying a habitation with intent to damage or destroy a habitation. It looks like Cedar Ridge Apartments. You started a fire and placed it in the wooden patio of the habitation. And that was within the city of Port Arthur. Anyway, it's a first degree felony. Do you understand what you're charged with here?
Yes, sir. Yes, sir.
If convicted, you face a term of life imprisonment or any term of not more than 99 years or less than 5 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes, sir.
An agreement's been reached where you would be pleading guilty, placed but not found guilty. You would be placed on deferred or unadjudicated probation, fined $500. Is there any restitution on this?
No.
And this deferred or unadjudicated probation will be up to 10 years. You do well and it gets shortened. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Sir.
I told you you'd be fined $500 as well. I show you, and again,
No fines.
how do you plead? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
You have to speak out so she can hear you. The court reporter, you can't, if you're not, they can't take that. I'm going to show you what's marked as State's Exhibit 1. You need to sign.
Oh, did I not my signature? Oh. Apologies, Judge. I seem to have missed
I'm going to
it.
show you what's marked as State's Exhibit 1. Did you sign that document, understand it, discuss it with your attorney, or the contents all true and correct? Okay, you got a soft voice. Make sure she's got to be able to take everything down. The court reporter here, she has to hear you. State's Exhibit 1 is tendered into
No,
evidence
sir.
without objection admitted. Among other things, this states you are mentally competent to enter your guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You are guilty of the crime charged and any lesser included offenses. You are giving up your rights to a jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. You were totally satisfied with the representation provided by your lawyer. All of this is true. It states, so help you God.
Yes, sir.
State's Exhibit 1, part of the record for all purposes. Pre-sentence report is waived.
Yes, Judge.
If nothing further, I'm going to find that you are mentally competent to enter your guilty plea, sir. It is freely and voluntarily made. You understand and appreciate the consequences of pleading guilty. You are pleading guilty today,
Sir.
voluntarily, knowingly, intelligently. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt of this first degree felony. But I am not going to find you guilty so long as you follow these terms and conditions of probation. I'm going to defer any finding of guilt. Now, this is for a term of 10 years, but we
And,
shorten it for good behavior. I can shorten it to as much as a third.
thank you.
There will be terms and conditions of probation. The probation officer will go over these with you here in a moment. Make sure you follow them. If you fail, your probation can be revoked. You can then be found guilty and sentenced in for this particular case. You were looking at any term no less than 5 years, no more than 99 years confinement or life imprisonment. So it's a very serious situation.
Thank you.
He's got how much time right now?
Judge, he's been in custody for 109 days.
The couple of things. The probable cause affidavit that was filed stated that this was a second degree felony, but intending,
It's because of the habitation element. Judge.
you know,
It's because of the habitation element.
because of the habitation, it's a first degree felony.
Correct.
And that's how it was indicted by the grand jury. And it says, knowing that would endanger the life of an individual as the apartment was occupied and the fire caused damage to the wooden railing. And it's apparently a video depicts the defendant doing all of this. All right. Here's all right. Even though there's enough evidence to find you guilty, again, I am deferring or postponing any finding of guilt so long as you follow the terms and conditions of probation. You have been in jail 109 days. You're going to be ordered to do 71 more days. I can order anyone as a condition of probation. God bless you. To serve up to 180 days in the county jail. And it's for this, I hardly ever do that. But when you attempt to burn down someone's home, that is as serious as it gets. Thus, this court would be failing its duty under its oath it takes to see that justice is done. If I did place you under the 180 days requirement, because this is a serious thing to burn someone out of their home, attempt to. I can't think of too much more serious than that. And the court's orders must reflect the seriousness of this by its orders. So you're ordered to do an additional 71 days in jail to complete 180 days. If you fail, though, on probation, I hope you don't. You're looking at life imprisonment. Do you understand what's happened? Fix this. He's not, for the record, he's nodding and not speaking out.
Yes, sir.
Like I've asked him to do. But
Yes, sir.
on the record, he nods. He understands. All right. Good luck. That is all.